Hi, good morning, everyone. Good morning, World Justice Forum participants. Good morning to the colleagues here and also the ones online. Thank you so much for joining us. Before we start introductions, just for logistics, this session is being recorded, just so that everyone is aware and is comfortable with that. Thank you very much. And there is French and Spanish translation. For those in the room, there are headsets on the side, and number 1 is Spanish, and channel 2 is French. And for those that are joining us online, there is also Zoom translation for you. This is a hybrid event, so we have colleagues online. We have some of them here with us. We will also be taking questions from those of you online. So again, thank you for joining us. I'm Alexandra Meyerhans. I'm the program manager for our global program on rule of law and human rights with UNDP in the Crisis Bureau in New York. I'm joined by my other UNDP colleague, Lara Deramé. And a very warm welcome to our 2 panelists, and welcome to all of you to our Justice Futures CoLab launch. We're very welcome and happy to have Ms. Darine Salhieh, Chief Prosecutor and Head of Family Protection Prosecution Services from the State of Palestine with us, and Madam Rabia Javeri, Chairperson of the National Commission for Human Rights from Pakistan. Thank you very much. Thank you. We also have 2 UNDP colleagues online, Leanne McKay and Sarah McCoubry, that will be joining us for part of the discussion, so welcome to those of you. And we do have a very tight schedule. We're trying to get through a lot, so I will not take much more time, but to welcome you, and then to also hand over to Katie Thompson, who is the head of our team in New York, the head of the Rule of Law, Security, Justice, and Human Rights team, who unfortunately could not be here in person, but is very happy to welcome all of you via a video message. So over to Katie. Thank you very much. We are hoping her video will start, but I guess we'll see if that's working. Otherwise, we will continue. Can I get a thumbs up from tech? The video is coming. I think we might be struggling with that video. I apologize.
Good morning, distinguished colleagues and participants of the World Justice Forum. I'm really pleased to welcome you all here, albeit just virtually, and I'm so happy that UNDP is having this side event to launch our Justice Futures CoLab. As much as we delve into the context around the rule of law and access to justice, many people across the world in Ukraine, Afghanistan, Myanmar, many parts of Africa, and many parts of Europe and North America experience crises in access to legal aid and justice. Here in UNDP, we are pursuing this work at country level, regional level, and global level with an effort to preserve, restore, and support rule of law systems. We want to address justice gaps, and we want to increase the protection and promotion of human rights everywhere. We regard spaces such as the World Justice Forum as particularly important to share our experiences and to build knowledge and experience sharing across the globe. Over the course of these past days, you've probably heard about the rule of law crisis. You've been occupying yourselves with issues around justice and global justice needs. So what we'd like to do today is to highlight some of the efforts we've been making in UNDP to respond to the justice crisis. During the COVID-19 pandemic, what we've seen across the planet is a massive uptick in digitization and the accelerated use of technology in the justice sphere. And this obviously was accompanied at the same time with sometimes blockages in access to justice and sometimes greater need for accessing justice in regards to responses to gender-based violence and the needs of women in particular. What we decided to do in UNDP was to undertake an extensive reflection and consultation on what was happening in the access to justice sphere. We wanted to capture the learning and understand the challenges that were happening in the countries where we operate. This process included commissioning of a report called the Justice Emergency, which will take stock of the current situation and analyze the growing and changing justice needs during the pandemic and as we hope to move towards the end of this pandemic. And we also wanted to use that report to shape the way that UNDP is responding. The conclusion of the work is really to ensure that the way that we respond to this demand for justice and realize the transformative potential of justice service provision is really about rethinking traditional conceptions of how we do this work. And it's with that in mind, and with the being aware of the complexity of justice systems, being aware of the impact of politics and political decision-making on the success of justice systems, that we know that we need to understand that to have the courage to think and act differently in today's uncertain world. We've embedded all of those ideas and propositions into the global program, Phase 4. This is UNDP's framework for how we deliver support to rule of law, security, and human rights. And we're now moving forward with that program until 2025. We're extremely happy with the framework, but of course the framework is nothing without the work we do at country office level and with our partners across the UN system and beyond. And one of the pieces of building partnerships is the establishment of the Justice Futures CoLab that we're really happy to have launched today. This CoLab is the embodiment of many ideas that were already at play within UNDP as we try to use innovation and digitization to enhance access to justice in the countries which we serve. But it will also now be an explicit commitment to our exploration, innovation, and being open to new ideas about how we tackle the justice challenges of today and prevent injustices tomorrow. In Phase 4 of UNDP's global program, we will embrace the people-centered approach to justice services and justice service provision. This will be a core component of how we work in the rule of law to achieve transformative change. I want to talk about a couple of examples of the work that we've been doing. For example, in 2021, major milestones were achieved in strengthening transitional justice and the fight against impunity in Central African Republic, where we've recently had the first public hearings of the Special Criminal Court. I also want to talk about how we work in Somalia, where we have, through alternative dispute resolution, managed to support over 14,000 individuals to access justice in 2021. We're extremely pleased about those efforts. Finally, I just wanted to mention South Sudan, where we, through the deployment of 8 mobile courts in extremely challenging terrain, we have been working to support the prosecution and investigation of very serious crimes such as rape and murder. We've seen, against a backlog of cases, an increase of case processing up to 86% from around 57% before. So we're really pleased with these developments. Justice, it's never enough, but we know that we need to do more and reinforce these efforts and support our colleagues on the ground, and of course to work closely with survivors of violence in these efforts. The Justice Futures CoLab, which is anchored in the Rule of Law, Security and Human Rights team and under the framework of the global program, is really one of the next steps that we're very excited to see. As you're going to hear discussed today, this is going to be a space to generate knowledge, learn and explore innovation in the sector. We want to look at new tools and technologies and really ask the difficult questions about how to achieve justice transformation. We're really aware that we don't have all the answers. We're very aware that practitioners across the systems don't have all the answers. So we want to be working with our partners at national level and globally to pilot new approaches on these various thematics. So today is the launch of that, and in a way we want to embrace that spirit so that we are open to partners, we strengthen collaboration, and we really hope that many of you will reach out to us as a result of what you hear. The side event that you're at now has really conceived to be a sneak preview of our annual meeting on rule of law, security and human rights, which is going to take place on June the 21st and 22nd. And we will there officially launch the global program Phase 4 and the Justice Emergency paper that I mentioned earlier. So I really hope that you can all join us. It's a virtual event. We'll be able to continue the conversation. Everybody is invited to participate. Please don't hesitate to register, and please don't hesitate to be in touch. I'm very glad to have been able to join you virtually today, and I hope you have a very enjoyable event.
Thank you very much. Over to you, Lara.
Thank you. Thank you, Alex. Good morning, everyone. My name is Lara de Ramey. I'm Justice Specialist in the Rule of Law, Security and Human Rights team. Excellencies, distinguished participants, and dear colleagues, it's also my pleasure to be here today for this special launch. So now we are going to have a closer look at this Justice Futures CoLab, our new open space for exploration, innovation, and action that wants also to be a call for transformation and an influencer of change. So what is the CoLab? The CoLab is a physical space first. We are going to open offices in The Hague soon, a little bit later this year. But it's also, of course, a virtual space for collaboration with our country offices, our regional colleagues, and of course our partners and networks. So what will the CoLab be doing? We will be working through a virtuous cycle of first scanning all the justice challenges and new opportunities, questioning, exploring, testing and piloting innovations, generate knowledge, and of course communicating. The themes of the Justice CoLab are, for now, access to justice, constitutional assistance, environmental justice, transitional justice, gender justice, and of course, e-justice and digitalization. Today, it is our pleasure to launch not only the CoLab, but also some of its work. We have reports and knowledge products launching today. First, the Beyond the Pandemic, the Justice Emergency, a report authored by Ms. Leanne McKay, Senior Justice Advisor in our team, and 3 knowledge products prepared by Ms. Sarah McCubbray, Access to Justice Strategist. We have a report entitled E-Justice, Digital Transition to Close the Justice Gap, a toolkit to support strategic transition through e-justice, and we also have a global map of justice initiatives worldwide that I invite you to look at. So for more information about the CoLab, I suggest that you check our website. We have distributed the QR code that you can find in the room on some of the seats. We also have some printed copies outside. And on these links, you will also be able to find the reports that I've just mentioned. So please have a look. And now I'm going to give the floor to our colleagues online, Sarah and Leanne. I see Leanne is already there, Sarah as well. And they will discuss a little bit more about the why, where this idea of a CoLab came from, and also about the how. What does that mean in practice to work through this CoLab, using the example of our e-justice and digitalization work. So Sarah and Leanne, the floor is yours. Thank you.
Thank you very much, Lara. Thank you for the introduction. It's really a pleasure to be here today, and it's a pleasure to be participating in this short conversation with Sarah. Launching straight in, I think we're here to talk about why are we worried about justice now, and I don't think that anyone watching today could doubt that we are facing a global justice emergency. We all know that the quality of democracy, of rule of law, of protection of human rights, these things have been in decline for several years, and the number of autocracies are increasing. And I think the COVID pandemic, it did more than just highlight or exacerbate injustices and the weaknesses of governments and systems and institutions to deliver justice. But I think it also really revealed how shaky the foundations are upon which we've rested these global goods of justice, of rule of law, of human rights. So the justice emergency didn't come out of nowhere. It's been building for a long time. But what I think is critical today is the sense of urgency that accompanies it. And this urgency comes from a number of factors. I think one is the simple fact that we live in a very different world today, very different to even just 10 years ago, for a range of reasons. The geopolitical scene is very different. The role of non-state actors, including transnational corporations, for example, these actors are wielding immense power and influence, not only over governments, but also over societies. Climate and environmental challenges, these have been there for a long time, but there's now, they're critically time sensitive. And as just was mentioned by Lara, you know, our focus on digital technology, this technology is accelerating in a way that most people are unaware of, let alone understand, and yet is having a massive impact on our day-to-day lives. But I think that there's another element that's really driving this urgency, which I think is really important for us to recognize and to also understand. And that's the dramatic surge in social mobilization in recent years, including some of the largest protests that we've seen in world history. And I raise this in the context of the justice emergency, because if you look at some of the research and analysis that's been done on protest trends in recent years, you see this common thread, and that is this demand for justice. You know, literally across every continent, ordinary people are taking to the streets, demanding an end to injustice, to inequality, to impunity. These are demands for fair and just and more accessible legal systems and institutions. There are demand for an end to corruption and impunity. There are demand for social, economic, racial, gender, environmental justice. So the context has changed, and with it, the urgency has increased for us to tackle both these long-standing justice challenges, but also to tackle the emerging justice challenges, such as those connected to digital technologies, for example. So what UNDP has been grappling with, and really where the Justice Futures CoLab emerged from, is this question of, well, what does the justice emergency mean for our work in promoting justice and sustainable development now and in the future? And I think what is emerging from this complex context is a real momentum and a genuine commitment across the wider justice community towards really rethinking our understandings and our approaches to justice. And I think fundamentally acknowledging that the old ways of working are just no longer fit for purpose. So I think there's a growing recognition that really to achieve the transformation of unjust and unequal systems, we need to have, as Katie said, that courage and the commitment to think and act differently. And what I see is that development and justice practitioners and organizations are really starting to embrace that complexity of injustice and innovating in terms of how we understand justice problems, the types of tools and approaches that we're adopting in our work. And there's also been significant innovations in technology within the justice space. As Lara mentioned, we've seen impressive developments in e-justice for advancing access to justice, for increasing transparency and accountability. And, you know, this is the space that Sarah's been working in. And, you know, Sarah, I wonder from your perspective, what does the justice emergency mean within the e-justice space? And what does e-justice bring to our response to this justice emergency and the justice demand?
Thanks, Leanna. I think it's a really good question because as you framed the justice emergency, we do need to think about the different tools. How do we approach differently? E-justice is a strategy. It's an approach. It's a tool for responding to that justice emergency. Historically, we've often treated e-justice as an infrastructure project left to technologists and administrators of courts. And when we do that, we miss the opportunity to respond to the justice emergency with a rights-respecting, people-centered approach. E-justice is a tool for system transformation, not just for efficiency, and for really improving justice. E-justice can be strategically employed to advance sustainable, rights-respecting development, but only if those planning and implementing transformative change fully understand the positive and negative implications of these new digital tools. Before giving some examples, I thought I would explain a little bit of what I mean by e-justice. E-justice is an umbrella term, and it captures all kinds of digital technologies: case management systems, apps and information technologies, remote or virtual courts, e-filing, online dispute resolution, artificial intelligence, predictive sentencing, technologies used to digitize, store, provide access to legal documents, evidence, apps for human rights monitoring, interactive legal information for users. E-justice includes the technologies and the process reengineering, automation, data collection, and integration of these systems. It's the tools that are used both by justice sector professionals and by the public or the media. And with that overview, with those examples in mind, I want to highlight some of the positive and negative implications from a development-focused rights protection lens, because I think really understanding this positive-negative dynamic is critical if we are going to bring this as a strategic tool to the justice emergency that you've laid out for us, Leanne. There is no simple answer to whether technology will advance equality or undermine privacy, whether it will strengthen the rule of law or decrease access to justice. We need to cultivate a nuanced assessment of the implications of e-justice to let us in the development community both react to and lead e-justice design that prioritizes equitable and sustainable development. I'll give you a few examples. Thinking about access to justice and the digital divide, we can see how online courts, electronic filing, virtual hearings give people access to justice processes without traveling to a court, without having to be in the same room as their abuser, for example. Using adaptive technology can increase access for people with disabilities. On the flip side, it can also entrench or exacerbate the digital divide and exclude people with linguistic, literacy, and socioeconomic barriers. Turning to preventing or embedding discrimination, data collection can be used to identify and respond to patterns in discrimination, long hidden or denied. On the other side, if we embed bias into artificial intelligence to replicate the discrimination of human decision makers, we run a real risk. With those protests you mentioned earlier, we see surveillance data leading to targeting the people who are pushing against power structures. Data and privacy has both sides to it. There are huge risks in terms of who owns data and can access data, contrasted with the value of digital identities available to people who are displaced, migrating, or excluded based on minority identities. And if we just look at cost, technologies reduce the cost if people don't need to hire a lawyer, don't need to make multiple trips to court, or don't need to worry about childcare when they meet with their lawyer. Those all make legal services more affordable. But the need for devices, data, and infrastructure is expensive. No technology, digital process, or service is uniformly positive or negative. Identifying and understanding the potential and the risks equips decision makers, all of us, to make careful decisions about e-justice projects. And like any other tool, it can easily become the focus itself. We lose sight of the overarching priority on meaningful system transformation, that system transformation that the justice emergency calls for. So Leanne, I think with that kind of snapshot of e-justice, I think it raises questions about how do we respond with a sustainable development-centered approach.
Thanks, Sarah. And your final point there, I think, is really critical. This link between e-justice and the potential for systems transformation. And I think it's that transformative ambition that is really the key. The global justice demand that I mentioned is fundamentally a demand for transformation of entire legal, political, social, economic structures and institutions. Structures and institutions that have for a very long time been indifferent to the injustices that they cause or contribute to. So I think when we unpack the justice emergency and the justice demand, it becomes quite quickly apparent that there's a narrow approach to justice that focuses on laws and lawyers and judges and courts. That's not going to be enough to enable the transformation that's being demanded. What's required is this approach that understands justice from the perspective of those who suffer injustice, that places justice firmly at the heart of development, and that mobilizes a wider range of tools and approaches and perspectives to enable us to better understand and ultimately transform those systems really across development contexts. So, and it's really this approach that I think is reflected in the design and the ambition of UNDP's Justice Futures CoLab. This space that Lara introduced for collectively questioning, discussing, and then constructing new ideas and approaches to these justice challenges. So within the CoLab, there's a strong emphasis on the use of data and analysis to better understand justice problems, which is an area you mentioned where technology can be an incredibly powerful tool. It's also about engaging a wide array of disciplines, perspectives, expertise, experience in strategic conversations to better understand the drivers of injustice and collectively innovate solutions. Because responding to this broad justice demand requires us to do more than just transform the justice sector. It's about transforming unjust and unfair policies and systems across sectors such as health, education, housing, employment, in order to tackle injustice and exclusion. And clearly that can't be done by justice professionals alone. So it's really about involving the right people at the right time in the process of innovating solutions and acknowledging, which some lawyers might resist, that not all justice problems require a justice or legal solution, but that through more integrated ways of working, we can better ensure that development interventions generally can better address the symptoms of inequalities and injustice, and also contribute to the efforts of transforming and moving towards that sort of systemic and structural change. And of course, key for us being able to innovate solutions is being able to take learning from our past efforts and actions and build upon those. So it's really about having honest conversations about why the past approaches haven't produced the results we expected. We know, for example, that justice is complex and inherently political. That interventions that seek to challenge and transform unjust systems interfere with foundations of power. So it's about us really tackling those questions around how can we better navigate those elements of complexity, of power, of politics, and having those conversations about what are the real barriers and the opportunities for us to all think and act differently. So for me, I see it as a balancing act. We need to balance that urgency to act with investing the time and the resources in ensuring that we diagnose and understand the problems correctly, which in turn allows the potential solutions to emerge more easily. So, Sarah, when we look at the e-justice work that the CoLab has been doing, what do some of these new ways of thinking and responding actually look like in practice?
I think it's always good to take these kinds of big ideas and put them into that concrete example. And in the CoLab context for e-justice, I think there's two really big ideas I want to focus on. The first one actually touches on a question one of the participants has asked here around what does the future of e-justice look like in terms of more lawyers, less lawyers? Do we need judges? Do we need to change the laws? I think what we really need to do is shift the scope of our thinking. We need to move away from thinking about projects and into thinking about systems change. We need to stop thinking about the system the way it is and what works best for system actors, and start thinking about what works best for the people who are relying on the justice system, and start there. and then build the system that will support that. Touching on some of the ideas you've raised, and frankly, reckoning with all the questions that are being asked there in the chat around what does a justice system informed and using digital technologies really look like? We might need some bigger imagination. And that's where bringing the CoLab together lets us think about that differently and learn from other contexts. We need to collect data and use it differently. Instead of looking only at data as a project evaluation tool, we need to start working with it earlier, using it as a tool to understand how people experience justice and to bring that people-centered lens into the design. We need to be engaged in strategic project design, talk about rights and the rule of law early in the design process and tie that into monitoring and evaluation. It can't be an afterthought. And then we need longer timelines with commitments from our partners and donors that will be sustained as an initiative experiments, adapts, occasionally fails. I think this step of expanding the traditional role of the donor from just a financial partner to a partner engaged throughout the process, invested in the overall goals, is one that we know many donors are already interested in. They're already invested in meaningful system transformation and are prepared to stay with projects through setbacks, experiments, changes in partners or implementation plans. But e-justice has really shown us that system transformation takes time, investment, and nurturing of adaptation. The second big idea I want to talk about is really linked into what the CoLab has been working on, and that's to build the capacity of our teams. Because this kind of transformation is also going to be a transformation in how we work, how we as a development community work. We need to connect the expertise of teams across a technical divide. Technologists need to understand more about rights and development. Rule of law and human rights focal points need to be comfortable and confident talking about technology. We can't keep deferring to each other and leaving our issues out of those discussions. We looked at over 200 e-justice projects, and they're all connected on the global e-justice map that you can find on the CoLab site. And there, we saw a wealth of expertise and experimentation that has happened in e-justice. Some of it through UNDP projects, some of it through other development agencies who are leading in this area. And so many projects seem to start from scratch and repeat past mistakes. We saw common lessons learned. And instead, the CoLab is looking to build capacity by sharing that expertise. We also want to move away from rigid roles and sort of accountability frameworks that penalize innovation. Instead, we need to start rewarding experimentation and building confidence in that tech evolution that centers development goals. We as a development community need to own our own expertise. We need to stop assuming that technologists or the private sector or the system administrators are the only experts in e-justice. We actually bring a critical expertise that should be at the center of design around what changes in technology and digital tools mean for data security, for privacy, for human rights. We are critical to making sure that the evolution of courts doesn't simply start glossing over or ignoring these critical ideas. So to address this capacity, the CoLab not only is sharing the global map, but it also has a new set of tools that country offices can use, that can also be used and shared with donors and other development partners. We'll be offering training in July to build that capacity. So there are ways to think about how do we connect around these learnings and spread that out across our infrastructure. I think there's so much potential to harness this opportunity. And that's just thinking about e-justice, let alone environmental justice, gender justice, all of those other pillars. Leanne, you know, as we start to move into those other areas, what do you see as those first steps for how we start to connect that and make that work?
Thanks, Sarah. Look, I think that there is a huge amount of enthusiasm and desire amongst justice and development practitioners to really have these sorts of conversations and to really explore how can we work differently, how can we test our new ideas and our approaches. And as you alluded to, you know, that enthusiasm needs to be nurtured and it also needs to be enabled. And that means, as you said, more than just ensuring that practitioners have strong subject matter knowledge. You know, if the transformation of complex systems like justice systems takes time. It's not a linear process. It requires us to have an understanding and skills and tools to work in politically informed and adaptive ways, for example. It's about understanding how to navigate complexity and complex systems. and how to facilitate effective change processes. And critically, as I mentioned before, and you also reiterated, it's about nurturing that learning mindset that says we can, what we learn from our failures is as important, if not more so, than what we take from our successes. And I think in essence, really, if we want to advance a new way of thinking and acting, we also have to build that muscle memory, that avoids us from sort of slipping back into the old ways of thinking and the old ways of working whenever we hit an obstacle. And I think it's really important that this is not seen as a task for practitioners alone. You raised a number of points around what needs to happen to fully realize the potential of e-justice that involves commitments and investments from organizations, from governments, from partners. And so I think that's, for me, really the final point that I want to emphasize today is that to respond to people's needs and justice demands, that requires a collective endeavor. It requires courage, commitment, creativity on the part of practitioners, organizations, and partners. And it's about cultivating that enabling environment for change to happen, both organizationally, through more expansive partnerships, and in the way that we're designing and delivering our programs. So fundamentally, this is the ambition of the Justice Futures CoLab, to enable an approach to justice that starts from the perspective of those for whom justice is absent, to be a space for innovation and experimentation, to promote learning, to better inform our programming and to better inform those policy decision-making, to cultivate strategic partnerships that recognize that change is hard, that it requires dedicated long-term commitment, requires creativity, and of course, it requires collaboration. Thanks, Sarah.
I think that's a great call to action, and it makes me excited about the work the CoLab can do. And I see in the chat some really concrete, interesting questions around how do we think about political will? What happens in militarized environments? What does this really mean for data and human rights? And that's a great segue into us highlighting some of the examples of what's happening in the e-justice space, where we can see some of how e-justice has been used to deal concretely with access to data that advances human rights. We're going to give you a chance to hear a little bit about some of those projects and then hear from people involved from and benefiting from some of those e-justice. And I think some of them will be able to address these questions because I'll turn it back to Laura to welcome the national counterparts and to talk about how these projects are making a meaningful difference on the questions you're raising in the chat and also on the issues of the justice emergency that we've laid out here today. Over to you, Laura.
Thank you. Thank you, both of you, for this inspiring conversation. The floor is now to Alex for the presentation of some concrete examples of our work at country level.
Thank you very much. Thank you. Yes, Leanne and Sarah, I think that was very insightful and also very inspiring. So thank you very much. Before we turn to our panel, we will have some short videos of some of the examples of our e-justice work. We actually have examples from Brazil, Pakistan, and the state of Palestine. And we will start with our first video from Brazil, presented by the UNDP Deputy Resident Representative, Carlos Arboleda. So if we can get that video up, that would be great. Thank you.
UNDP has worked with the National Justice Council in Brazil on two important projects, the Justice 4.0 and the Making Justice projects, which are targeted to improve justice effectiveness and access through innovation and digital transformation. The projects include the use of artificial intelligence, data analysis, and systems automation to streamline justice processes, reduce corruption, address gender inequality, and improve human rights protections. Technology is used to avoid human rights violations in the prison system, increase the access of ex-inmates to socioeconomic inclusion, opportunities, optimize judicial workflows, and increase transparency, improving the rule of law. The projects are collaborative effort with courts, judges, and other partners to innovate and ensure an effective and human-centered justice in Brazil. One of the initiatives developed in Brazil is the implementation of national digital system to monitor the implementation of criminal sentences, including alerts to judges on penalty progression, conclusion of penalty time, and other rights of the persons deprived of liberty. This avoids human rights violations. The system has a special focus on vulnerable persons deprived of liberty, such as LGBTQI persons, migrants, indigenous persons with disabilities, and pregnant women. At the same time, it allows access for anyone involved in the process to relevant data. Another set of initiatives in this partnership focus on improving justice effectiveness. As an example, artificial intelligence tools are being used to improve gender mainstreaming on judicial analysis, identifying bottlenecks on justice procedures, and improving the transparency of justice data. A national digital platform for the judiciary is also in place, allowing the collaborative development of digital solutions among the 90 Brazilian courts all over the country, optimizing costs and improving results for citizens. Collaboration was fundamental for the project's success. The partnership includes the courts in the 27 states in the country, as well as regional and specialized courts and other justice system actors. It involves the executive power, academia, and civil society have an active role. The private sector has collaborated with solutions targeted to the socioeconomic inclusion systems. Partnerships in the UN system are also in place, including UNODC, UNOPS, UN Volunteers, and ILO. Some of the initiatives of this partnership have already received international recognition, including a place among the finalists in the World Justice Project 2021 for the actions targeted to the prison system in Brazil. A series of reference documents, methodologies, and digital solutions developed on these projects can be scaled up and shared internationally. Tools and guidelines for applying artificial intelligence to justice and for strengthening data transparency and anti-corruption measures, contributing to the efforts for continuously advancing towards a peaceful, just, and inclusive society.
Wonderful. Thank you so much. Thank you to the colleagues in Brazil for that video. We will now go on to the next example. This is actually an example from Pakistan, and just to let you know, for the ones asking questions online, we will have some time at the end to take those questions. Also for you in the audience, we do have some Q&A time, but please do keep posting your questions in the chat. We see them and we will get to them eventually at the end. But for the next example, we will move on to Pakistan. We're also very fortunate because we actually have our colleague Amar Hassan here from Pakistan as well, so if you have specific questions, he is here in the audience with us. Thank you very much, and then on to that video, please.
UNDP Pakistan worked with the Ministry of Human Rights and provincial departments to develop the Human Rights Information Management System. This collection, monitoring, and reporting approach allows for aggregated data to identify trends and focus on key priority areas. The system embeds Pakistan's international obligations and integrates into country reporting on the Sustainable Development Goals. It is being used at the national and subnational levels to particularly address human rights challenges faced by the most vulnerable populations in Pakistan. The HRIMS is an inclusive data collection and analysis mechanism. This ensures that access to justice challenges are highlighted, reported, and addressed. Having this human rights data is the first step in responding to issues faced by the most vulnerable populations in Pakistan. The project offers a platform to national and subnational government entities, including federal ministries and provincial departments. It allows reporting on progress and challenges related to the strengthening of the rule of law. This ensures that policies and interventions are inclusive, rights-based, and focused on the most vulnerable and at-risk populations. On partnerships and collaborations, the project adopted a three-tiered approach. Firstly, strong partnerships were established at the grassroots level with civil society, especially focusing on the most disadvantaged groups. Secondly, national and subnational government counterparts, including NHRIs, were engaged to promote dialogue with civil society. And thirdly, at the international level, the project collaborated closely with OHCHR, the governments of Germany and Switzerland, to whom we are thankful for their continued support. And with the system now operational across Pakistan, we look forward to supporting the government in reporting against Pakistan's treaty body obligations and the UPR process through the HRIMS. The SDG targets and goals are embedded in the system. Therefore, any progress made against HR indicators is also mapped against a relevant SDG. We have also held consultations with other UNDP offices as well as external partners on the potential of replicating the project in countries facing similar challenges. And we look forward to continuing and sharing these best practices with all partners.
Thank you very much for that. Thank you, Omar. We will go on to our next example. The last example actually comes from the state of Palestine, and we're also very fortunate today because we have several colleagues from PAP here. Yvonne, Chris, Omar, Murad, thank you so much for being here in person. And again, if anyone has questions, happy to take those at the end. So please, over to the video.
Mizan 2, a collaboration between UNDP and the Palestinian judiciary, is a case management system that started with a case file for the court, then expanded to court filing, evidence storage, and scheduling access for lawyers. The system integrates with other ministries, linking family support, enforcement, corrections, and financial institutions. The system uses a predefined templates for all transactions and hearing minutes, available instantly online for all parties of the case. It allows for electronic enforcement request and scheduling appointment at the notary public. This was particularly handy under the COVID-19 restrictions. Direct public access has been added using public terminals. The system facilitates the lawyers' interaction with the courts and their clients through access to e-services, which saves them the need to be physically present in the court for any service or inquiry. It also serves as an anti-corruption and transparency tool within each court and each prosecution office. The system provides gender-sensitive and human right-based case classification. The segregated data allows for improved policies that are directly in line with the SDG's goals. Part of SDG 5 and SDG 16 indicator are extracted directly from Mizan 2 by the Palestinian Central Bureau of Statistics. The system ensures connectivity between the various justice actors, which opened the new frontiers for collaboration and brought prosecutors, judges, judicial police, and lawyers together on a round table to discuss things like optimum timeline for cases, case classification, and eliminated unnecessary process through these discussions. An e-justice team was established, and the e-justice team task was to identify all services that can be digitized in a way that ensure different solutions that are being developed at different institutions can all talk to each other. In 2018, Sawasi, in association with the Judicial Authority, launched a user survey for the Mizan, in which 91% of the judges stated that Mizan is an effective tool to speed up the litigation process. And overall, 87% of the Mizan users stated that they are satisfied with the program services. It's important to say that in Palestine, the Mizan 2 has been constantly improved by the High Judicial Council and shared with other justice institutions under bilateral MOUs. The project is looking at expanding and exporting Mizan 2 to other countries as a digital public good. Several discussions took place with UNDP rule flow programs in the region to share the Mizan software as part of fostering South-South cooperation.
Thank you so much for that. I think that gives some great examples of some of the work that we're doing. Of course, it's not a full showcase of everything, but we hope that provides some insight. And now we will turn to our panelists to hear from them. So thank you for your patience as well. And thank you again for being here. Lara, over to you.
Thank you, Alex, and very happy to welcome, very pleased really to welcome you both, Madame Rabia and Ms. Dareen, for this panel. We have been hearing about those really impressive projects in Pakistan and in the state of Palestine, and I invite you now to give us a more concrete perspective on what these systems are having as an impact in your respective countries. So I will start with Madame Rabia and ask you. First, I'd like to flag that you're serving today as a chair of National Human Rights Commission, but the former hat you had as a federal secretary in the Ministry of Human Rights in Pakistan. So you are you've been witnessing the building of this system. Can you tell us a little bit more about this system and about the data that has been collected, that is being collected through this human rights monitoring system? Can it be used to serve the people's needs? Will it ultimately improve access to justice?
Bismillah ar-Rahman ar-Rahim. Good morning, everybody. Good morning, Madam Dareen. Thank you, Lara, Alex, and good luck to the lab for this innovative space, which I hope will, wield a lot of positive results in the world. Well, the HRIMS started as a necessity. We in the government were greatly hampered and challenged in three different areas. One, we were compelled to do externally, the compulsion was reporting. How do we send a report internationally in a devolved country where human rights are not really the whole, and human rights monitoring and digitalization of data is not the top priority? How do you create a central nerve center to gather information and then authentically relay that information during any treaty body report? And it was this necessity and this challenge that led to the collaboration between, then I was Secretary, Ministry of Human Rights, and the UNDP. And the idea was to create a system, to create a comprehensive methodology, as you saw in the movie, both at the ground level, at the provincial level, and information coming forward to a central repository. And that was one demand, the external demand of Pakistan having to monitor. The second demand, which is relevant to access to information, is how do you use information? Because when you use data, good data, authentic data can propel action. Good data, sensitive data, timely data can lead to timely interventions internally. So the data that is gathered through the HRIMS on the various indicators would then pool in to create interventions in terms of policy, legislative interventions, interventions institutionally, which cover the whole gambit of human rights, of which access to justice is one. And the third thing is, in Pakistan, when you talk of human rights, our way of acting or responding is reactive. So many people have died, so many rapes, so many abuses, and we react. Can we use that data to not just be reactive and not just talk about the bad stuff, but to get a comprehensive, wholesome look at the trends that I think somebody mentioned it here, the trends that are moving in human rights, the trends that are moving in in access to justice. And of course, there are many challenges because the data has to be sensitive. The questions have to be sensitive. The data has to be timely. The data has to be authentic, and there must be systems of verifying the data. But once the data is there, that's the foundation, the hinge pin on which you can move forward. And I could give you an example of policies that were based on data that was received, for instance, in rape amendment in the rape law, looking at complaints received with regard to education and looking at policy interventions in education. So that's the whole gambit of the external, the internal, and sort of our way to move forward in the ministry, to sum it up. Thank you.
Thank you very much. So this is very interesting. It's I think an illustration. We are not only building these systems to support institutions, but ultimately we will be able to use them to improve the situation. And thank you for bringing examples of policy developments thanks to the system. It's we still have time to see how it will evolve, but it's very promising. Now turning to Ms. Dareen, welcome again. And so you are speaking as a chief prosecutor in the state of Palestine, and you are also head of the Family Protection and Prosecution Services, which will give us a very interesting insight. So how would you speak to that? How is the mise-en system supporting access to justice for people?
Thank you very much for your question. And actually, it's very important to say that what does the access to justice mean? Actually, the first, what is its definition? And access to justice is a basic principle and rule of law, and that describe how the citizen have an equal access to the legal system, and how we can design all the program that can provide these services, especially to the population that may have difficulties in legal presentation and legal representation and legal advice. And in the light, actually, of the rapid technical development and in the context of a global transformation to globalization, the Palestinian judicial system interact with it positively and effectively by how we can enhancing these services that we are provided for the population as a legal system in a way reflected the ability to deal with this development and to find a framework that do not violate the human rights, and focusing on how we can also making a gender mainstreaming to this population as a vulnerable group that they cannot obtain several services like the others. So putting and find framework that set up the uniform case evidence management system and develop a data management system of courts, it was very potential and very necessary to work and focus in, especially when we are talking in Palestine and the privacy of Palestine that is under occupation. And these all contexts of Palestine, when we are talking on the territorial fragmentations and movement destructions caused by the Israeli occupation, so that cannot be able for the people to go and to obtain the access to justice. So these services and the flexibility of these services and the flexibility of working remotely by especially important during COVID-19, and it wasn't a crisis not for just Palestine, it was globally, and it was also to be found and to understand how we can deal with these crises without violate the human rights, and how we can also to have good practices for the future crisis, especially for Palestine, because we always live in crisis. And so Mizan was very important and improve access to justice through what was the videos represented, increase the ability of the judicial system to provide information and services easily. So one of the examples that moving from paperwork to electronic work has a great impact. As a prosecutor was hired in 2002, just our work was in a paper, with dealing with the evidence by paper, so you can't even imagine how it takes a time and how it's taken effort of that. It's reducing the physical access challenges, and this is very important when we are talking on with the vulnerable group, especially women, people with disabilities, and elderly people, and also minimize and reducing the number of times that people come to the court. This is very important, especially when we are talking on the restrictions of movement and how we deal with these needs. The third thing that achieving a full transparency in access to these services. When we are talking on, and the example of that random electronic distributions of the cases for the judges and the prosecutors, making it and transparency in these whole affairs, and this is maybe a very important impact for the citizen, how he can deal with these services. Avoiding long waiting periods and shortening time and efforts of justice user, such as a booking, and it was a very essential thing and services, including during the pandemic. It's how can I booking online appointment in advance for notary public services, and how can also schedule my scheduling as prosecutor working in the emergency cases and emergency period. So this was very important and successful. Promoting the security of information and data protection. It's been very important when we are talking on gender sensitivity, especially when women are seeking for not just for accountability, and also they are seeking for the protection for data, protection for their life, and how can I making a tracking system between our stakeholders to promoting prevention and protection, also enhancing with the accountability process, which is a long-term, not a light-term, how we can deal with it. Also giving the data and access, who will access the data, how we can disclosure and making limitation to access this data. Accountability if someone violates the or their maybe I don't know how to explain it, but identify access with the privilege with the clerks and with the prosecutor and with the judges. It was very important thing for the transparency of our daily work. And the third, maybe the most important thing is also how I can give supports for the judges for shorten that long time to organize their agenda, and how also can having all the informations and all the judgments that they were established as High Judicial Council, how they can do it. It's very important because it's helpful for them to use it. So access to justice with Mizan as a system to refer to access to justice and how we can connect it with do not violate, and how we can give more and more stages for the Palestinian citizen. It is very important, especially we are under occupation, and always we have a violation of human rights there.
Thank you very much, and very interesting to see so very concretely responses when we talk about accessibility and physical accessibility, because you of course, you were able to deal with the COVID-19 pandemic crisis in better ways thanks to this system. But especially in the state of Palestine also, we know that it's interesting to hear that it also overcomes the problems of movements that you're facing in the region, and that facilitates access to everyone. And then the spotlight on the need also for the women that have their other challenges when it comes to come to the court. So I thank you so much for these concrete examples, and also you spoke about the transparency and accountability that it brings to your work. So I think it's a very comprehensive set of benefits that we can hear from this system. I am going to ask now Ms. Rabia, what would you say about this other aspect of accountability and transparency? Is this system also bringing some benefits in that area, you would say?
Well, thank you, Lara. I'm going to talk a little bit about my current assignment, which is this Chairperson of the National Commission on Human Rights, which is a quasi-judicial entity. We have the powers of a court. We can intervene in civil and criminal proceedings. We have suo motu powers. And we are also a complaint receiving body. And when you talk about e-justice, and it was very well said, I think, by Sarah, because e-justice really is a tool. It's a tool for efficiency. It's a tool, if wisely used and sensitively used, can certainly move processes forward. And what we did in the Commission was we're trying to look at the whole supply chain of access to justice. So what we're looking at is, first of all, early warning. Can you use technology? Can you use algorithms within social media to actually prevent an offense taking place? Pakistan has recently been subject to a lot of mob violence. We've had nearly 6 cases of mob violence, which is very, very disturbing. Can you use technology to sort of curtail an event that's going to happen? One. Second of all, if people do come to you in the court, we are in our capacity, we have a complaint system which is now being rehauled and digitized to be able to identify, as we mentioned, trends. For instance, what are the trends we are seeing both in people's perception to us? Can we use that information? For financials, it's financially cheaper if people come online through a use of this e-system. One, it's faster. We have been in the actual prison thing, and I'd be very keen to hear about what they did in Brazil. We've been trying to advocate for e-courts. For instance, the court in Adiala, we have the powers to visit areas of detention. They take 500 people every morning to court. And those 500 people are lined up and then they're put in court. It's a huge logistical nightmare. And we're trying to advocate that they be not taken, at least for the minor cases, so we could have e-courts, and that's one of the areas in which the Commission is trying to push very hard. We've already brought it to the notice of the judiciary. And then how can we use our data that we receive because we have a certain role as a watchdog and as an advocate, a driver of human rights discourse? Can we use the data we receive to propel the government and push the government for legislative or policy or even institutional change? And that's how we are looking at the entire sort of gambit or the supply chain which is access to justice from beginning to end. Our role in advocacy against, for instance, the death sentence. And can we use that role? And that's what we're trying. We're a new entity, and we're finding our feet, but we are getting traction. And that's work in progress. So basically, if we can establish systems and technology, as I heard somebody say, is here to stay, how can we ensure that it's worked for its best purposes? How can we get the best out of that technology? Thank you.
Thank you. Thank you very much. It's more work and more work to support. Indeed, I think it's what you say is let's explore, right? The potential of these tools. We know that there are a lot of risks, and we have to be careful when discussing those systems. I think we are going to hear now. I'd like to ask Ms. Dareen, because you're a prosecutor, and I'd like to hear a little bit more from you on how you concretely, use the system in your daily work. How does that help you? And I think there's this confidentiality of data is one of the things that comes up. So that would be interesting to hear.
Actually, as a prosecutor, working in specialized prosecutions as a Palestinian public prosecution, how we can deal access to justice for vulnerable group, this is our work as a specialized prosecutor. So Mizan system is a great systematic example on which how we can reflect the SDGs goals, especially goal number 5 and goal number 16, because they are cross with each other. So how we can interact with these goals and how we can reflect it in our daily work, especially when we are talking about vulnerable group. Mizan was ensuring a safe and responsive environment that facilitates for women and vulnerable group to access to justice, in a way respect their privacy and in a way respect their dignity and the confidentiality of the information that we can obtain of it, especially in the sexual cases. Consider it as a tracking system so that we can also provide the prevention and protection in the whole system when we are talking on the accountability. Accountability, it's begun from the first point, from the first day that they are reporting to the police until to the law enforcement that the public prosecution, Palestinian public prosecution, have the authority to do it according to the law. So protection, how can I ensure the protection in these data? And when I'm talking with our stakeholders about which kind of the information that I can share with them, this is very important also. When we are talking also in legal obligations toward juvenile and minors, we have an obligations according to the law that we need to have a security for the informations for the juvenile, and how can we deal with it without putting also a record with another institution because he's a juvenile. It was also very, as a Palestinian government, we were putting the first report for CEDAW Convention in Geneva in 2018, but we used all the analyzed data that we haven't obtained from Mizan to saying what is our obligation towards this convention and which is the obstacles that we cannot collecting the data. And as Ma'am mentioned, it's very important and potential to put which is the challenges and which is the changes we need to improve it in the legal framework and also in our relations with another stakeholders, even if they are national or international. Palestine, as again, as a country under occupation, have a lot of obstacles that we needed even in reaching to seeking for protection and prevention. The thing that you were asking for me, I'm not now talking as a chief prosecutor, I'm talking as female. Maybe as a victim, she cannot seek for access to justice without anyone can improve for giving for her a powerful encouragement and also empowerment in all the procedures, because she will have an encourage to come and to reporting, but believe me, she cannot have an encouragement or to continue the whole long procedures in accountability without someone can encourage her. How she use the whole system to encourage her. So Mizan was a good system. collecting data with the privacy and collecting data with making the all gender aspects. It was very important to us as prosecutors, especially when we are talking on West Bank, and no one can not understand what is the privacy of the West Bank from the transportation or the whole system that can we deal with the Palestinian privacy.
Thank you so much for these very concrete examples. It's wonderful to hear that this project is really providing concrete answers to those issues. Because we are running a bit late with our schedule, I'd like to now turn to questions from the floor. So I don't know if anyone has a question. We see nothing from here. So please, I would suggest if you do have a question, you stand up or raise your hand. And you have to use the microphone. Yes?
Please, go ahead. Just go to the mic so that online they can also hear you.
Okay.
Do you want to start? Thank you.
Thank you for the question. Data has to be in a sort of circular pattern. And that's something that I and the Commission have learned greatly about, how civil society and the public gather a momentum of concerns. And the Commission, for instance, filters it and puts pressure on the government to create change. That's how data works. If data is, and it has to be gathered sensitively, and I keep saying that because sometimes it's gathered in a very mechanical way without understanding the sensitivities involved in different cultures. So if data is gathered sensitively, it processes from the grassroots level. It's gathered there through the provinces and then up to, in Pakistan, to the federal government. And that data should be used in a circular manner to create legislative interactions or to create legislative change. For instance, you gather data, for instance, some of the data we've seen in rights of inheritance. Women are denied their right of inheritance, and when you see these huge gaps in accessibility to land, for instance, which is only 2% in Pakistan for women. Now that data is concrete data gathered which propels change in terms of how do you improve women's access to ownership of land? What policies are there, and what are the challenges that those women face in access to land? In disabilities, you gather data on disabilities. And I'll give you an example. In Pakistan, they had, when they did the census, the question they asked was, is there anybody in your house handicapped or not? And everybody said, no, nobody. And so one of the big project problems was to put the Washington questions. Ask the questions sensitively, can somebody walk without an aid? Can somebody see in the dark? So how do you put those questions? Because the questions are very, very, very important. And use that data. And I think Pakistan is starting to see it. And then the second of all, the data is given to the government or the policymaker, but the data should also be accessible to the public, because that's where your transparency comes in, that's where your accountability comes in, that's where competition comes in. You find out, if you see a judgment of a particular judge which is not that effective, and you see one that's effective and it's in your face, that's how people start improving the quality of decision making. So it has to be cyclical. If it's one way, it's a waste of time. It has to come back in some form, changed in some form.
Thank you.
Thank you.
Very much. Ms. Dareen, do you also want to address that question?
Also, there's a very important thing to mention it, that data and statistics, it's not just a number. Yeah. We need to have good practices from these numbers and how we can enable better understanding of the reality that we are, and which is the thing that we need to improve it. These numbers, especially, and I'll give you an example of that, honor killing, for example, in Palestine, we're raised as in statistics. When we're making analyze for these numbers and see what is the relationship, for example, between the victim and defender, which is places that it's increased and which places district that decrease, it was give us how we can analyze these numbers and set up what is our needs and what is the next step, how we can avoid to have increase for murders, and how we can put also maybe amendment the law, amendment the punishment, and also make a rehabilitation project, because we do not just put an accountability, we also need to focus on the society and how we can provide these services without violate, especially when we are talking about the privacy of the family. How can I put all my effort to end the violence, but also how can I give support for this family to not re-victimization? And this is very important, how we can make sure that these numbers can translate it in the reality. This is the thing that we need to focus on it.
Can I just add one thing? I think what Dareen has brought up is really, really important when we're talking about the CoLab, when we're talking about data, is we dehumanize data. It's very easy to say, okay, 5 rapes, 10 murders, they're numbers. And that's something we keep facing, is that number is a human being, a human story, a human violation. And that's something we have to be very, very careful of when we're dealing with data, is we tend to step back and it's just a number. Mm-hmm. So just to qualify what.
Thank you. Thank you so much. And indeed, and this is among the challenges ahead, right? We still have work to do and how to achieve that. Indeed, I think, Alex, I don't know, maybe we want to ask some questions from the chat. Just a reminder that we have also people attending online.
Participants, yes, absolutely. We are almost out of time, so I will just ask one question from online, and maybe if you can respond to that. And it's about how we know change in the justice sector is hard. Of course, there are also many opportunities offered, but it is challenging. And the question here being asked is, the justice sector, it's linked to political will. And how can e-justice contribute to change this, changing human attitude, improve capacity so that justice can be administered properly? So maybe you can just, give a short example on the issue around political will, how that has been addressed through these systems, and any kind of advice towards that would be great. Ms. Dareen, do you want to start?
Yeah, actually, this is very important. Also, when we are talking on the sensitivity of Palestinian Authority, as the absence of the parliament and how the political will be interactive directly to our daily work. But also, we do not. It's very important to know that we have an obligations according to the convention that we are working on it, and this obligation give us how we can reporting our effort to deal with these fundamental rights according to the human rights. So maybe the most challenges that we face it as a legal system, how we can enhancing our daily work, how we can enhancing our obligations without with the absence of the parliament and with the absence of the whole system that we are live in. So obligations according conventions and how we can also, this is very important, and maybe thankful for Sawasiya program as a prosecutor that give us an enhancing our comprehensive knowledge, how we can making our daily work not just reading the articles according to the penal code, but also how we can having the ideas, how we can having comprehensive daily work with the victims by focusing on the good practices for her according to the fundamental rights, not according just with the legislative, because legislative, you do not, if you do not have a building capacity, you will read it in a negative way, but if you have an open mind according to the fundamental rights, believe me, you will change in your understanding of that and how you can give push for the victims, not just putting as a bridge between you and between the victims. This is very important for human rights to impress and to having in a process more and more in the future.
Thank you so much, Ms. Dareen. Thank you.
You're welcome.
Ms. Rabi, would you like to come in?
Well, yeah, change pinches, you know, but I don't think we should underestimate the power of the people, the power of public awareness, and the power of that downward thrust to change and to advent political change. And I think that's when you have that kind of accessibility and awareness and access to data and information, that is the very true change that can come. So sure, but data can work to create that awareness, which can work to inspire the people to a better future and hence put political pressure to create a better world. Thank you.
Thank you very much. Thank you. I think that is unfortunately it for this panel, but I have to say we've gotten a lot of questions online and just a lot of positive comments for all of the insights that were shared. So thank you very much to both of you. Also very proud and happy to be on this panel of 4 women and the other 2 women we had online, which I think is fantastic. Thank you so much. We do have one last speaker, very quickly. We're very grateful also for the support that we get from the Dutch Ministry of Foreign Affairs. And we have Ms. Cecile Groot here, the Senior Policy Officer for Rule of Law from the Dutch Ministry of Foreign Affairs, that will just make some closing remarks. And we are sticking to the women's trend here, so it's very nice. Thank you so much.
Yeah, really, we are.
Yeah, it works. All right. Good morning, everyone. I'll try to keep it short because I realize I'm between you and a coffee and a good conversation. I thank you, UNDP and distinguished panel, for a very insightful and inspiring session. As UNDP has clearly argued in this last hour, the Justice Futures CoLab will allow the organization to add considerable capacity, thus enabling UNDP to more systemically explore, innovate, and plan and deliver action in addressing today and tomorrow's complex justice challenges. The justice emergency, as mentioned by UNDP colleagues, and also the country examples that were presented, show the importance of innovation to find justice solutions that address people's justice needs and priorities. People-centered justice is also at the heart of the Netherlands' access to justice strategy and our approach to improve access to justice for people. This is aligned with our global commitment to support the implementation of SDG 16.3 with a focus on helping those furthest behind. For the Netherlands, our partnership with organizations such as UNDP is instrumental to implement our policy goals. In that regard, we are proud to be a long-standing partner to UNDP, in particular to the Global Program, but also as a partner in global networks such as the Justice Action Coalition. In order to continuously improve the way we as international development community can support the delivery of effective justice solutions, all involved actors, international and national partners working at global, regional, and country levels, need to systematically collect and analyze relevant quantitative and qualitative data from our programs and projects in an effort to understand what works and what doesn't work, which has already been emphasized by the previous speakers. This will enable us to incrementally build up a collective empirical evidence base that informs our policy and programming in the area of people-centered justice support. We as the Netherlands consider the Justice Futures CoLab thus to be a timely investment by UNDP. As a donor, we see a growing trend within the development community, and we note increasing investments made by implementing organizations to monitor, evaluate, and learn from their work in order to capitalize on the wealth of experience and expertise being accrued within these organizations and to prepare evidence-based programming better. We are confident that the work of the Justice Futures CoLab will help improve the work UNDP does under the global program, as well as rule of law programming done at country level. And in this process, we would like to invite UNDP to work closely with other international and national partners when identifying knowledge, evidence, and best practices. There are various organizations within the justice field, some of whom the Netherlands also supports, who have embarked on a similar path of exploration and innovation during the last years. The UNDP Justice Future CoLab can learn from these efforts, just as these other efforts can be enriched by UNDP's work on this area. We encourage UNDP to continue to use this platform to engage with partners, both international and national, representing implementing organizations, think tanks, and donors, to share its vast knowledge and practice base on international justice support, which will undoubtedly grow broader, deeper, and richer as a result of the Justice Future CoLab. Thank you. Thank you.
Thank you very much, Ms. Cecile Groot, for your closing remarks, and thanks again to the Ministry of Dutch Ministry of Foreign Affairs for their continued support for justice for all and people-centered justice. The Justice CoLab wouldn't be possible without you, so we're really grateful. It's time to say goodbye. I would like to thank everyone for joining us online and in person today. We hope you enjoyed. I would like to thank very, very much our panelists again for your sharing today. It was really special to have you here, and it's also inspiring for us, because when we hear how these projects actually bring a change and transformation at country office level, it also motivates us to continue and pursue our work. So very big thanks. I also want to thank the UNDP colleagues who help us to put this event together. We are working from New York on policy and guidance, but the real work is at country level. So thank you so much for this collaboration. I also have to remind you that we have our annual meeting on the 21st and 22nd of June, and you will hear more about the Justice CoLab, of course, and the environmental justice work that we do, and constitutional assistance, and many other things. We are engaging gender, and etc. So I'll stop here, but don't forget the Justice CoLab is also an open door to collaboration. Not only internal to UNDP, but also with networks and partners. So please do reach out, and we'll be there. Thank you so much.
Thank you.